Hello. We're now continuing with our examination of the substantive portions of our Constitution, and we come to this very interesting section of our Constitution, Article 1, which deals with Declaration of Rights. Note that in many state constitutions we have the Declaration of Rights way up front. They're not tacked on somehow later after the Constitution's adopted, as in the federal Constitution, with the amendments being put in place to give protections after the Constitution was adopted. Do recognize that some state constitutions were in existence well before the existence of the federal Constitution. And so state constitutional law have begun to develop on some subjects before the federal Constitution even had protections for individual rights. There were some protections for individual rights, as we've seen earlier, and we'll touch on those once again as we go through this assessment. But today we want to look at Article 1, and we want to look at the differences between the state Declaration of Rights and the Federal Bill of Rights, give some thought to which of the provisions of the state Declaration of Rights are different from those in the federal Constitution, and to give some thought to how those might be applied in terms of litigation. Think about how the differences in the Bill of Rights in Florida now expand on rights and give very specific rights to things such as privacy, whereas those rights are implied in the federal Constitution. And throughout all of this, I want you to be thinking about how you might use the state Constitution if you have occasion to try to protect people's individual rights, and think about whether state constitutional litigation is really a useful alternative to federal constitutional litigation. Let's begin with political power. This is now Section 1 of Article 1. The 68 Revision Commission moved these sections around a little bit, but essentially this provision has been a part of the Florida Constitution since the very beginning. If we look at this language, it looks like something very comparable to the 9th Amendment to the U.S. Constitution. All power is inherent in the people. We'll not find very much case law that spells this out, but do always remember this if you're arguing cases for individual rights. And now I want you to pick up your Florida Constitution and turn to Article 1, Section 2. It's entitled Basic Rights. This section contains Florida's equal protection language. And I want you to look at that language closely. All natural persons, female and male alike, are equal before the law. Now, just to pause on that language, you might very well think that the Florida Constitution now sets up an excellent basis for challenging any barriers on same-sex marriage. But you have to look to the end of Article 1 to find a very specific provision that defines marriage. So any implication that you might find in this language of Section 2, you're going to find repudiated in a later portion of the Constitution. And so it's unlikely, without federal decision or further amendment of the Florida Constitution, that we're going to see same-sex marriages approved by Florida courts. But the language doesn't stop here. It goes forward with some language which I think you'll find fascinating. And it's language that's built around the phrase inalienable rights. Inalienable rights. So all persons have inalienable rights, among which are the right to enjoy and defend their liberty, to pursue happiness, and to be rewarded for their industry, to acquire, possess, and protect property. These are inalienable rights. Now, I want you to pause and think about the word inalienable a little bit. It really, alienability is a concept that we get from property law. If you alienate property, you sell the property, you get rid of it. Now, if you have inalienable rights, you have rights you can't get rid of. And there's that old philosopher's question, if a man is truly free, is he also free to sell himself into slavery? Well, the answer for people who believe in natural law and inalienable rights is no. You don't have the freedom to sell yourself because there's some things that are so basic to your very existence as a human being, you cannot get rid of. And you can't even get rid of it for money. You can't sell yourself into slavery. So think about inalienability. Think about the fact that we now have in the Florida Constitution a phrase and language that is not in the federal Constitution. We do find it, of course, in Jefferson's Declaration of Independence, but not in the Constitution. But the Florida Constitution, along with constitutions in a number of other states, picks up this idea of inalienability. And when you can find places where you apply it, that apply the inalienable right to be rewarded for your industry, for instance, you might be able to use those phrases to advance your client's interest in constitutional litigation built around the Florida Constitution. Again, these rights go beyond those in the federal Constitution. I'm continuing forward with that same language, and it relates to the ownership, inheritance, and disposition of property by aliens who are ineligible for citizenship, and that allows that to be regulated or prohibited by law. Now, it continues on giving protections relating to people's rights, regardless of their race, religion, national origin, or physical disability. Again, you have to pause on these individual words. What kinds of rights are respected and may not be tampered with by legislature without some legislative showing of an extraordinary need for legislation. You cannot tamper in the federal government with race or religion. These are suspect classifications. But look at the suspect classifications under the Florida Constitution. It also includes national origin and particularly physical disability. So this is a restriction on the Florida legislature in terms of adopting legislation that will now deprive anyone who has physical disability of their rights. And so it's a new suspect classification for purposes of constitutional analysis, one that's not present in the federal law, but very important in Florida law. Again, there's so much in Article 1 that's interesting. It's tempting to look over Section 3 and say, oh gosh, yes, we understand these principles. These are the principles that are in the First Amendment. We have protection for freedom of religion. We prohibit the establishment of state religions. So we understand this language. But read on. Make sure you understand everything that's in Article 1, Section 3. There's also this idea incorporated in the Florida Constitution that there are restrictions on expenditures. The revenue of the state may not be used directly or indirectly, in aid of any church, sect, or religious denomination or in aid of any sectarian institution. Now we're going to have stumbled across this a great deal in litigation relating to Article 1, Section 3, and you've got to recognize that Florida has a provision relating to this subject that is not in the federal Constitution, and this section is referred to as the Blaine Amendment. This section I've just emphasized, and James Blaine of Maine had at one point run for president. He was a member of Congress. He had attempted to amend the federal Constitution unsuccessfully, but a number of states adopted what is called the Blaine Amendment into their state constitutions, and Florida is one of those states. The Blaine Amendment has been attacked by a number of people as being in itself discriminatory, but it's in the Florida Constitution and has been used repeatedly, as we will see when we examine the case law under Article 1, and when we get to the education article, Article 9, we'll find that the Blaine Amendment has a major role to play as we look at the funding for education. Freedom of press, freedom of speech reads a little bit different from the First Amendment, but in practical terms, most of the issues, particularly issues built around the law of defamation, have now been constitutionalized under the federal Constitution and are now First Amendment issues. Back when I was in law school, eons and eons ago, we learned defamation in our course in torts. Today, I think law students learn about defamation in their course in federal constitutional law. And so federal constitutional law has occupied the field, and there's very little room for state principles, but do remember that there are state principles, and some of those, including certain privileges, have not been entirely displaced by the federal jurisprudence. We see this curious language in the state constitution saying that if a matter is defamatory, is actually true, and was published with good motives, the party shall be acquitted or exonerated. And that's the reason for this language, is that historically in Britain and early colonial days, there were prosecutions for libel, seditious libel, libel against the state, and the idea was developed by case law at that time was that truth was not a defense. You could be prosecuted for defaming the state, and the principle at British common law was the greater the truth of what you said, the greater the libel. So if you told the truth, it was damaging to the king. You could be punished more for telling the truth than for telling a falsehood. Now that law was displaced in the United States and is displaced quite clearly in Florida. But as you read that curious language, it has no particular application in modern law. And it is the case of New York Times versus Sullivan that began the series of cases that you'll want to look at if you're looking at free speech issues in Florida. And as I've said earlier, state privileges still exist, but are very seldomly invoked by litigants. Right to assemble is pretty much a right that's consistent and construed to be consistent with the federal Constitution. Not a great deal more to say about that today. There is a provision on right to work. Don't look at the title of this and read too much in it. The right to work shall not be denied or abridged on account of membership or non-membership in any labor union. In other words, you may not have a union shop, but it does create a right that we'll look at when we look at the case law, and that's the right of bargaining, including the right to the right of, excuse me, I've now messed up my slides, including the right of public employees to collectively bargain. And again, we'll have to look at the case law to sort that out. Moving through from Section 6, Section 7 doesn't add much to our knowledge. The military power should be subordinate to the civil concept, very well accepted, not litigated in Florida. There's a provision on right to bear arms that goes beyond Second Amendment principles. Again, relied on by people who are attempting to conduct gun sales or trafficking in firearms. That provides for a waiting period. Notice that it's a fairly limited waiting period. It's a waiting period that relates to purchase of handguns. If you'd like to have an assault rifle, this provision does not say anything at all about assault rifles. It's handguns. And again, we'll have to look at the case law to fully understand this provision. Again, directives to the legislature, and the legislature actually has enacted laws that implement Article 1, Section 8. Again, now we return to a concept that we know really quite well from federal constitutional law, also embodied in Florida Constitution and Article 1, Section 9, is due process. And we have due process prohibition against taking of life or property without due process, have prohibition against double jeopardy, and protections against being a witness against yourself, all embodied in Article 1, Section 9. Now we have Section 10, which essentially repeats provisions of Article 1, Section 10 of the U.S. Constitution. So, according to the Florida Constitution and the federal Constitution, the state may not enact laws that constitute a bill of attainder, ex post facto laws, or laws impairing contracts. Again, some case law. Florida is not bound by the federal decisions and may, in some instances, stake out its own ground on any of these provisions and provide rights greater than those provided under the federal Constitution. We have a very specific provision on imprisonment for debt. We'd have to look at the case law to fully understand this provision. It does not prohibit courts from putting people in prison who do not pay child support or alimony pursuant to a court order. And so people can be put into jail for contempt of court and not released until they comply with the court order, so long as they have the ability to make the payments ordered by the court. And we'll examine that in more depth when we discuss the case law. Searches and seizures is one of the very interesting provisions of the Florida Constitution, because the legislature, reacting to some decisions by the state Supreme Court, has now modified the way we look at searches and seizures. I think I've said to you earlier that the search and seizure provision of the Constitution was expanded in 1968 revision, when an amendment was adopted that put restrictions also on interception of communications, on wiretapping or other efforts to get people's private information through electronic means. And so in '68 there was a great expansion of the right of privacy. But now look at what happens after the Florida Supreme Court has decisions that differ from the U.S. Supreme Court decisions on search and seizure. One of the famous cases related to a helicopter flying over private property. And when a helicopter flew below 500 feet in Florida to inspect your property to find out if you're growing marijuana or something else, the federal law said that was okay. But the Florida Supreme Court said, no, that's an intrusion into privacy, and that's an illegal search. You have to go through the warrant process and demonstrate probable cause. And the law enforcement officials, offended with the idea that we have this great protection for people's privacy, now go to the legislature, propose that we have an amendment, and this amendment is adopted. Look at what it says. It says that any decisions construing this provision of our Constitution shall be consistent with the decisions of the United States Supreme Court construing the Fourth Amendment of the U.S. Constitution, and now recognize that that this restriction relates to decisions by the U.S. Supreme Court. The Florida Supreme Court is still free to disagree with decisions of federal appellate court, federal district court, or others, but where a U.S. Supreme Court decision very specifically renders a decision, that's the end of it. In Florida, Florida's ruling have to be consistent with the federal Constitution. Habeas corpus, the great writ, very explicitly spelled out in Florida. This is the only place in the Constitution where you're going to find a filing fee specified. So what's the filing fee if you want to file a petition for a writ of habeas corpus? It is zero, nothing. You cannot be charged for filing a writ of habeas corpus. It's available to all citizens, and the great writ will allow courts to give you protection if you've been improperly detained by state authorities. And again, it shall not be suspended except in times that are essential for the public safety. Prosecution for crimes, we have essentially the language that we've had for some years. Capital crimes requires a presentment to the grand jury, and for other felonies, a presentment or indictment or an information under oath filed by the prosecuting officer with the court. There's a very specific provision relating to juveniles in the Constitution. Section 16 provides the rights of accused and victims. Again, this provision is a reminder to me that you have to really read all the words in the Constitution and pay attention to them if you've got a case. Look at this language. Everyone has a right to compulsory process for witnesses, to confront adverse witnesses at trial, to be heard in person, comma, by counsel, or both, comma, so in person, by counsel, or both. I had an appeal that I was handling along with a law partner. My law partner was a tax lawyer who agreed to handle a pro bono appeal working with the public defender's office. And he had a case that he had to brief that related to someone who appeared in court, and when he was before the judge, attempted to make a statement, and the judge said to him, "You've got counsel representing you, and you don't need to speak yourself. You can speak through counsel." Well, my law partner, this tax lawyer, actually read the Constitution and read it closely enough to understand that, in fact, there's a constitutional right to be heard not only through counsel, but individually and through counsel. And we won that appeal thanks to the fact that my law partner, this tax lawyer, read the text of the Constitution much closer than I did, because I entirely had missed this argument when we were doing the briefing. And so a good lesson to me and a good lesson to all of us to pay attention to the words of the Constitution. There is a provision in the Florida Constitution relating to victims. Again, recognize that this is not present in the federal Constitution. So the right of victims to participate in some manner, so long as it does not interfere with the constitutional rights of the accused, is provided for constitutionally. And you see this victims' rights process played out in many criminal cases. Again, we get to a section of our basic rights, section of our Declaration of Rights that has been amended through legislative proposal. This is the provision that's parallel to the federal 8th Amendment on cruel and unusual punishment. There was a time when the Florida Constitution referred to cruel or unusual punishment, and that difference in language was used by the Florida Supreme Court to render some decisions that rendered different decisions in application than the decisions by the U.S. Supreme Court under the 8th Amendment. And so following that, the legislature proposed amendments which included this very specific provision allowing capital punishment and provision which says that that the provisions of Section 17 shall be interpreted in a way that's consistent with decisions of the United States Supreme Court as it analyzes the 8th Amendment of the U.S. Constitution. Again, this pullback in authority of the Florida courts to differ with the federal courts. And the legislative fascination with capital punishment continues in Section 17 by constitutionalizing the legislative authority to set up methods of execution. Note that this language has not prevented further litigation relating to methods of execution, and we'll see as we examine the case law how this continues to be an area that's rife with litigation. A provision, again, not in the federal Constitution, relating to administrative penalties, introduced into Florida in the 68 revision. A provision relating to cost. Notice that this is limited. If a person charged with a crime may not pay cost before a judgment of conviction, but after judgment of conviction, they may be assessed fines and costs, and you'll find that those are sometimes really quite heavy, and there have been problems with the application of this language as it applies later, fines after conviction. To what extent can people be put in prison or jail for failure to pay a court-ordered fine? And again, I think the principles which we'll be able to derive from our examination of case law is that unless they have the means to pay the fine, they may not be put in prison or jail. A provision on treason. This, surprisingly, has not been litigated very much. Provision on access to courts, which has been litigated a great deal. This is an extremely important provision of the Florida Constitution. Don't read past this. and think that it's just a simple measure put in the Constitution. You're going to see as we examine the case law that this has some very important applications. So the courts shall be open to every person for redress of any injury. You have an injury, you're entitled to get to court and have a redress of that injury. And justice shall be administered without sale, denial, or delay. Now, where did this language come from? Let's look back at Magna Carta. Magna Carta, King John promises the people, the barons in this instance, that there will be law reform. And he promises, quote, to no one will we sell, to no one will we refuse or delay right or justice. So we won't deny justice, we won't sell justice, and so we promise, the king promises to have that kind of law reform, to reform the system of writs, where if you want a very powerful writ, you have to pay quite a bit of money to the king for that writ. The king takes that money and puts it in his treasury. This is now not permitted in England following the Magna Carta, although remember there were a number of Magna Cartas issued. It was not just the one in 1215. Over a period of time, the principles of the Magna Carta really morphed into something that was protective, but nothing as protective as what the courts in Florida have found the Article 1, Section 21 provision on access to courts to mean. It really means that if you, at common law, if you have a right for some remedy after you've been injured, that right cannot be modified by the legislature unless the legislature gives you some substitute right or some substitute procedure. So deriving from the Magna Carta, we have this extremely important provision of the Florida Constitution, the access to court provision. Trial by jury, again, consistent with the federal Constitution. Notice that the Florida Constitution now spells out the number of jurors. So the right to trial a jury shall remain invalid. But if a common law jury was 12 people, now under the Florida Constitution, the number of jurors may not be fewer than 6. We do not require now constitutionally a 12-person jury as is required at common law in many instances. Again, we come to something unique to the Florida Constitution and extremely important. This is the right of privacy. The right of privacy was first proposed in the Constitution revision sessions of 1977-78. The subject was originally introduced by Justice Ben Overton, who at that time was Chief Justice and a member of the Constitution Revision Commission. He gave an address to the opening session of Constitution Revision about the need to protect personal privacy, and ultimately the Revision Commission accepted his recommendation and crafted this language. The language was a bit different from what was originally proposed by Justice Overton, and it was drafted by a member of the FSU faculty, Professor Patricia Dorr, who had worked with members of the Constitution Revision Commission to craft the language. And look at the language. It says that citizens shall have the right to be let alone. Now, the Constitution Revision proposals of 1978 went before the people, and all of them were defeated. So we do not have the right of privacy introduced through the Constitution Revision Commission process, but following the defeat of all the proposals, a number of the proposals put forward in the 78 revision proposals were pulled out and offered separately to the people of Florida, and one of those, this provision on right of privacy, and it was proposed by the legislature in exactly the form that it was put before the people in the '78 election, and was rejected as part of the package of amendments from the '78 revision. But it was now taken up by Senator Barron. He had support from Professor Dorr to help with this process, and together they pushed through the legislature this proposed constitutional amendment. It went on the ballot in 1980. I think about the presidential election of 1980. Ronald Reagan is running for president. We now have a proposal of the Florida Constitution which says that Floridians should have the right to be let alone and should be protected from government. And it's not surprising to me that this time it passed. And we have this freestanding right of privacy in Florida, and we have so much case law deriving from this, and case law that we'll have a wonderful time discussing in our class. There's a section 24 that I don't want to linger on too long, but do note that this is unique to the Florida Constitution. So far as I know, there's no other constitution, no other state constitution that has a provision such as Florida's Article 1, Section 24, and it provides both access to public meetings and access to public records. These rights that are be protected, the amendment in the Article 1, Section 24 does allow exemptions, but those exemptions must be adopted in a certain manner. It requires a vote by 2/3 of each member of the members of two houses. So 2/3 vote to create an exemption, the legislation is required to have a statement of public necessity justify the exemption. And again, this is an area that has been litigated quite a lot, and my hunch is you will see in your law practice litigation on this subject a great deal during the course of your practice. The legislative authority to enact laws is put in this amendment, probably unnecessary, but here it is. And the legislature, in fact, has adopted not only laws, but also rules of the House, of each of the houses relating to public records. This savings provision of Article 24 now protects those exemptions that are already in place. Section 25. Another useless part of the Constitution, good idea to have a taxpayer's Bill of Rights, but legislature has authority to pass such legislation, and indeed this is something that when you serve in Constitution Revision Commission in 2017, you may want to just pull out as unnecessary. This is now a section of the Constitution which we discussed earlier when we were talking about the amendments, and we're talking about poorly drafted amendments. This is one of the amendments was offered by physicians associations to try to limit lawyers, and it turns out not to be effective at all, because this is a claimant's right, and the right can be waived. And finally, Section 27, a section which attempts to displace the possibilities of Article 1, Section 2, language relating to the equality of all natural persons, male and female alike. And it now makes clear that in Florida, marriage is a legal union of only one man and one woman as husband and wife, and no other legal union may be treated as marriage or the substantial equivalent. So no civil unions in Florida under this. Now remember, the federal Constitution is not in any way limited by this provision, and it remains to be seen whether this provision in the state Constitution is constitutional under federal law. But it is at least a barrier to same-sex legislation in Florida. We now reach Article 1, Section 27, and I must confess that I recorded this earlier, and I've made a terrible mistake. And therefore, for continuity purposes, I'm going to try to put back on the tie that I had earlier so that you won't be disrupted by my terrible mistake. And my mistake was talking about Article 1, Section 27 as though it was somehow immutable and it was going to be the law of Florida. The very day that I originally recorded the piece on Article 1, Section 27, a federal judge in Utah did a very strange and interesting thing. He invalidated the provisions of not only Utah law, but provisions of the Utah Constitution, which was substantially similar to what you see in the Florida Constitution. And he held that because the United States Supreme Court recent decisions had found provisions of federal law to be unconstitutional, as intruding on the rights of persons to enter into gay marriages, that Utah law was probably unconstitutional as well. And so we now have a provision in the Florida Constitution that seems like it is solid, that is now controlling, as we're going to see in other contexts. Provisions of the Florida Constitution are sometimes unconstitutional. And as we look at Article 1, Section 27, I want you to think about the case in Utah. The case, I think, was Kitchen versus Herbert, and is in 2014, January. It is now on its way up to the United States Supreme Court. Indeed, the U.S. Supreme Court now has ruled, as of yesterday, at the time of our recording, has ruled that they would issue a stay from the implementation of the federal district court judges in the Utah case. So this is a great example of looking at federal principles and state principles at the same time, and to think about what the ongoing federal litigation relating to the federal Constitution can do to the provisions of the Florida Constitution. And it's too early to predict the result, so I'll predict the result. This provision of the Florida Constitution is going to be found ultimately to be unconstitutional. And so we will wind up having gay marriage in Florida, not because of a new constitutional amendment, which is now being proposed to replace existing Article 1, Section 27, but is going to be found, our provision will be found to be in violation of federal equal protection principles. And we would have gone through the exercise of adopting this provision without any ultimate result at all. But it's going to take some years, and our class will probably be over before we get the kind of resolution, and before, in case I'm wrong, it'd be some time before you're able to tell me that I was wrong. But pay attention to what's going on around you, and I should have been doing a better job myself before I cut the original lecture on this subject. Thanks so much. Well, that takes us through the interesting Article 1. I hope it's laid out for you some of the real possibilities of protection of individual rights that are in the state Constitution but are not in the federal Constitution. And I look forward to discussing with you in class the case law that builds out these rights and helps us to understand them more completely. Again, thank you very much. See you in class.